All right, we are on the record now today for the 28th Circuit Court here in Wexford County, and we begin today's docket call by taking up the case of People of the State of Michigan versus John Burgess. This is case number 25-14157 FH. Appearances from counsel, please.
Joanna Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Burgess.
Thank you. Mr. Burgess joins us this morning via Zoom from a Michigan Department of Corrections facility in Ionia, I believe. Also here in the courtroom this morning is Miss Lindsay Simmons. She's an agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation and report. One moment. We are here today for a sentencing after a plea. A plea was entered back on or about December 8th of 2025. I have received a copy of the pre-sentence investigation report. All right. I did not apparently catch any corrections. Let's see if the council did. Ms. Carey?
No corrections.
And Mr. Harrison?
None for us either, Your Honor.
All right. Well, thank you very much. We are next at sentencing. Mr. Harrison, go right ahead, sir.
Well, this case presents a sort of an odd configuration, Your Honor, because on one hand, it's a pretty simple, straightforward case. It's a use of methamphetamine as a second or subsequent offender, a relatively low-level felony with a 2 to 17 guideline, despite Mr. Burgess's extensive criminal history. On the other hand, it's complicated because if you look at his Otis page, you will see that he was due to be released from his sentence in 2018. Obviously, that didn't happen. He's still in prison. There's parole violations, et cetera, et cetera. Right now, we believe his release date is July 26th, the upcoming July 26th, so 2026. That is consistently what Mr. Burgess and I have discussed. That is not what Otis indicates. Otis indicates a max discharge date only sometime in 2032. We don't believe that to be accurate either. So it presents something of a conundrum to the court in terms of the fact that this is a consecutive sentencing situation. The question becomes consecutive to what? If it's to his initial sentence, that's okay. He could serve it in effect concurrently with the time he's serving now due to his parole situation. If it is subsequent or consecutive to his current term that he's serving due to his violations, then it would have to be tacked on at the end. Perhaps he could even come back here and serve a little bit of jail. If you'll also notice in the report, Your Honor, this incident occurred a long time ago. He has 87 days from the time that he entered the plea in this case. I know he doesn't get day-for-day credit for that, so that's not what I'm asking. What I'd like for the court is simply to recognize that he's been there. I don't know what else to say about this. This is a sort of a silly event that occurred where he scared a bunch of people because he was in a place he shouldn't have been, making noise about wanting to talk to somebody who apparently didn't live in that neighborhood. That's what drew the police attention, rightfully so. And you can see by even a quick glance at his criminal history that he has struggled with addiction and substance use, et cetera, et cetera, et cetera, for most of his adult life. I think he's reached a point in his life now where he's tired of being on the revolving door. He's tired of doing life on the installment plan, and he has a better plan for his future. And he has some stuff he needs to clean up and clear up and take care of. This is the last of those things. Other than this, it's simply a matter of obtaining his ultimate release date, making some plans for the future, completing some programming in the MDLC, and moving on with his life. Thank you.
Ms. Carey, on behalf of the people, ma'am.
Thank you. What we have is Mr. Burgess, who, while on parole, got arrested in Osceola County for the aggravated indecent exposure. And a couple weeks before that, he was here in Cadillac on this case and got kicked out of the Sun and Snow Motel, walking down Sunnyside Drive, saw what he believed to be an abandoned house, went in the backyard and had his pants down, I don't know doing what, and the homeowner had video and was alerted to someone on his property, and the police called and they found meth residue on him. We had someone on parole breaking the law, not once, but twice that we know of. And this is not the last case he has to take care of. He still has to take care of the Osceola County case that sent him to prison. I think the defendant has shown that he is not supervisable. I think his recommendation for incarceration is well reasoned, and I'm going to ask the court for a sentence of incarceration. And I know the guidelines are 2 to 17, but given his behavior, his performance on parole in the past, and his lengthy criminal history, I think it's appropriate. Thank you.
All right, Mr. Burgess, you have the right to make a statement before the court issues a sentence, sir. Is there anything you wish to say at all?
No, I'm all right.
All right. Well, let's do a little walk through the defendant's criminal history, which began as an adult 30 years ago in '96. Couple assaultive issues back in '96, 2 of them going on at one time. He made it about 4 years after that. Picked up just a petty theft case. Then he had a couple-year gap. Looks like about 3 years before he picked up an unlawful use of a motor vehicle. Made it 2 days after that. Oh, wait. Oh, he was on bond. I'm sorry, I've got that. He was on bond pending the 1 unlawful use, picked up a 2nd unlawful use. When that case was resolved, he was on probation for about 7 of his 12 months and picked up a 3rd unlawful use. So in other words, the same offense. We're starting to wonder about the defendant's ability to learn from his choices. Now in that, thereafter, that looks like he made it about 4 years before he picked up a case here up in Wexford. And it was just a disorderly person, which seems to be a little bit similar to what we have in today's case. After that was resolved, he made it about 10 months before picking up some other felonies. So it looks like it was resolved with a misdemeanor plea. And he violated probation within 4 months, and he did so on 1, 2, 3, 4, at least 4 different occasions over his first 10 or 11 months of probation. One of those was assault and battery. Looks like after he was off of probation, he was released from probation on December. Hold on a moment. Ms. Simmons, if you could please turn to CFJ 284, page 9, looking at entry. 15 of 26. The offense date was December 19th. If you flip backwards, you'll see that for at the top of page 8, entry 12 of 26, his discharge from probation was 3 days thereafter.
Yes, sir. My apologies. I was looking at the 12-15 one.
Yeah, I figured that. It's all right. I didn't see it earlier myself. So for entry 15 of 26, he was on probation at the time.
Okay.
That probation was terminated. Plus, 1 month later, he picked up another charge. Now here we've got disorderly conduct, surveilling an unclothed person. He had probation, multiple probation violations in that file as well. So we have some disturbances of the peace and, you know, interruption of people's privacy living in this community. Then in 2017, while on probation, he picked up an aggravated indecent. Looks like, yeah. Well, he had a charge for indecent exposure, for which he was convicted. Possession of meth, sounding similar. He then, when I look at the narrative, while on probation, he was sent back for the aggravated indecent exposure due to violating his probation. Entry 12 of 26 occurred while on parole for the previous cases. Entry 21 of 26 also occurred on parole. Oh, by the way, entry 20 was another disorderly person. There's some more batteries. When we get to entry 22 of 26, occurred while on parole. Tampered electronic monitoring device, by the way, which is not the first time. She had another one of those previously. Let me go back and make sure I'm correct. I'm sorry, I saw malicious telecommunication use. I was wrong. So I continue. Then we pick up, or the defendant picks up the, while on parole, this particular offense, plus, well, this case was, before he got arrested on it, he picked up another case for aggravated indecent exposure in Osceola County. And again, do we have any resolution of that file?
Not to my understanding, Your Honor, no.
So we have an individual who repetitively is out there interrupting people in their neighborhoods, in their home, in their community, exposing himself, which, by the way, in this case, he was walking around with his pants down. At least he chose a day that was in the summer. I think this one was in June. Luckily, it wasn't December. But he was disturbing people. And this is one of the problems where drug cases are not a victimless crime. And now you've got an individual who's walking around naked up to people's houses in residential neighborhoods. This was out on Sunnyside Drive. Well-traveled road, of course, here in Wexford County, and obviously a residential area. So it's quite concerning to this court that the defendant continues to violate the law. That's number one. Number two, that tends to be where he's either violent, disruptive, walk around naked, peering through windows, and involving methamphetamine or controlled substances here. So in this particular case, the court not only finds reasonable grounds for a period of confinement, we're seeing the same repetitive history, which is going to establish the proportionality and reasonableness of the sentence. The defendant has a difficulty being supervised, a difficult time complying, and a difficult time keeping his pants on. Court sentences the defendant to a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. There are no supervision fees. There are no DNA fees. I assume DNA was already available. Okay. I see that, so now the question becomes a period of confinement. The court recognizes that the defendant has, how long has he been in custody? Hold on.
He was returned on
7/24.
Well, no, this offense occurred on June 30th of 2025. The charges were filed on October 6th, and he was arrested on October 17th. So
He'd been returned.
He was back in prison, Your Honor, on July 22nd of 25.
Oh, 25.
The Osceola incident.
I got it.
Yeah.
Returned to prison.
Oh, okay, the one that's still pending?
Correct.
They, parole board would use that to
Correct.
violate him, put him back in prison on his original previous felony. All right, thank you. Well, the court recognizes that any period that the court sets must be served consecutively. The defendant, again, scores an intermediate sanction cell, but there are plenty of reasonable grounds here today. The court sentences the defendant to a sentence. I'm recognizing, quite honestly, I was cheering for a prison sentence, but I also recognize that he's currently serving a prison sentence, and any sentence I give has to run consecutive, and he doesn't receive credit for that. So therefore, the court taking all that into consideration and establishing a proportionate reasonable sentence, I sentence the defendant today to, and I'm sorry, I also have to acknowledge that I'm sentencing within the controlled second or subsequent offense double penalty, which is with the discretion of the court. I sentence accordingly, and I sentence the defendant to 270 days. He receives 0 credit, obviously because of the parole detainer. That, of course, must run consecutive to whatever sentence he is serving on the parole detainer. Have I missed anything, Ms. Simmons?
No, Your Honor. Thank you.
Have I missed anything, Ms. Carey?
No, thank you.
Mr. Harrison?
I don't believe so, Your Honor.
All right. Mr. Burgess, you will receive there at the confinement facility an advice of rights form. You should receive 2 copies. The first one you will place your initials on. Doing so neither elects or waives any rights. It merely acknowledges receipt of your copy of the document. This document will tell you that you have the right to appeal the conviction and sentence in your case, where that is typically done by filing a claim of right to appeal. Based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of this document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Now, today, everything I've said, I think, is pretty straightforward. Mr. Burgess, I hope that some of the things that Mr. Harrison said on your behalf are true, that you are tired of living life on this installment plan of sorts. We've been doing it now for 30 years. That's a long time. Really hope that you are seeking treatment there at the facilities. I hope that you are benefiting from it. And next time you get out, I hope that you seek treatment outside as well. You need to be attending AA or NA or some kind of program, or maybe speaking with community mental health, because you are presenting yourself to be a disruption to the community. You're also putting your health and life at risk. Thank you. We're adjourned.
Let's go back up to Michigan, see what's going on next with Judge Elmore, new contestant.
H, appearances, please.
Joanna Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. O'Neill. He's joining me at the table.
Thank you. Mr. O'Neill is currently in pretrial custody and has been brought here. Also this morning, I have Mr. Sean Benatmo. He's from the Michigan Department of Corrections to prepare today's pre-sentence investigation report. We're here today for sentencing after a plea was taken on December 12th, 2025. The conviction was for possession of a narcotic cocaine in an amount of more than 25, but less than 50 grams of cocaine as a second or subsequent drug offender. Ms. Carey, any amendments, corrections, or objections to make to the contents of the pre-sentence investigation report?
No, thank you.
Mr. Harrison, same question, sir.
Well, we have some troubling information to update. Let me get the page numbers in regard to his medical condition. On page 2 of page 284A.
I'm there.
It indicates in the penultimate line of this third full paragraph, life expectancy is 2 to 11 years. Unfortunately, that's more like 2 to 4 years.
Okay.
Yeah.
Ms. Carey, anything to add there?
No.
All right, we'll go ahead and make that change. Mr. Harrison, anything else?
What was that? I think the rest of it, I think we can handle through
Allocution.
elocution.
All right, thank you. All right, allocution, Mr. Harrison?
Well, let's talk about the elephant in the room. Let's talk about the number, the amount, the weight. I anticipated that was going to be of some degree of concern to the court, and it probably should be. Normally, you would have a situation like this, the court's perspective would be that this person was bringing this poison into our community, distribution to other people, et cetera, et cetera. That simply is just not the case here, despite the large amount of cocaine found on him, with him that day in the car. He was an exceptionally heavy user. So it's easy to look at the medical information, particularly the stuff that we just talked about, and say, well, this is a person who's completely given up due to having a terminal illness and has decided to ride out the rest of the time that he has on this planet in a drug-induced haze. I think that would be fair for someone to say that didn't have the perspective that is somewhat shown in the PSI and is well known to me. What is well known to me is that he's actively participated with Catholic Human Services in the jail and has attended AA and NA sessions as they were available. Most of them were NA. And he's completed the Catholic Human Services programming while in the jail, as the court can see in front of him, he has a vast amount of the little slips of paper as well as the certificates of completion for all of those programs. Now, what does that mean? What that means is that Colby is determined to do what he can to leave his mark behind when and if he does meet his maker, whether it's in the near future or a couple of years from now. He has mentored young people. I got a letter from a woman named Olivia who basically said that Colby is such an inspiration due to his perspective and outlook on life and positivity that she can't imagine that he was terminally ill at the time that he spoke with her, because she didn't know that at the time. That is typical of the conversations that I have had with people that know Mr. O'Neill. Now, that is not to say he doesn't have a drug problem. Clearly he does. Clearly a significant drug problem, especially in light of the fact that there's still a pending probation violation in front of Judge Mercer in Otsego County. Has that been resolved? Not the least of which was the amount of product he had with him here and his massive amount of daily consumption of that product. Pleased to say he has a different perspective. I'm pleased to say that he's decided not to go out in a blaze of glory, if you will, Your Honor, but to exert a positive influence on the people in and around his life. Now, the guidelines on this offense is 0 to 17. He has served 102 days in jail, and as the court is well aware, the recommendation is essentially for time served, perhaps a period of supervision thereafter. Colby welcomes a period of supervision because it will reinforce the plan that he already has to remain drug-free and to remain dedicated to preserving whatever time he has left with us. His cancer has metastasized, as set forth in the PSI, and the prognosis is not good, not positive. That's not to garner sympathy. That's not to garner leniency from the court. It's simply to make a statement here that I think is pretty compelling. He had really a couple of options of what to do. This offense, this incarceration, this whole process by which he's realized he spent 102 days in jail when he doesn't have that many days left, has really put a new spin on perspective of the world for Mr. Colby O'Neill. I would encourage the court to follow the recommendation. I would encourage the court to perhaps make inquiry of Mr. O'Neill with regard to his medical condition, if there are any unresolved issues there. I don't think there are, but there certainly could be. And at the end of the day, I think a period of probation is not only appropriate, I think it would be a good thing for all of the parties involved. Thank you.
Thank you. I'm going to ask the court to follow the recommendation for a period of incarceration. This is Mr. O'Neill's third conviction for the same behavior in less than 2 years. And he had 161.5 grams of cocaine, which has a value of about, I just asked Mr. Van Eckno, about $16,000. That's a lot of personal use. And when he was pulled over, he told the officer that he was trying to make medical bills. Now, it's interesting, the report, the PSI said that he was in remission until February of 2025. In December of this year, I spoke with the jail and got them updated. I asked for some information because I was considering his medical condition when I made the offer that I did. that he had been in remission since September 2nd, or on September 2nd. The information the jail had was that his leukemia was in remission. They had discussed continuing treatment with him because he's at a high risk of it coming back, and he declined that treatment.
I'm sorry, repeat that again?
He declined, he was in remission and declined. He's at high risk of it returning, so they wanted to give him some treatment, but he declined it.
Oh, okay.
And he wished to discontinue all treatment and therapy. And whether he's changed his mind, I don't know, but in September, that was the information. And I got that from the jail in December. That was the last information they had, and he had been, according to what I was told by the jail, seen by medical personnel there, because they were aware of his conditions. So I think what we have here is a person that is fairly reckless and is not taking his health into consideration. I think he is transporting and was delivering or selling or somehow involved in that, and using personal, because he was, when he was pulled over, he also had showed signs of use of cocaine. So we have someone in the last 2 years that's been in trouble for this. His wake-up call should have been the first time, but it wasn't. So I am going to ask for a period of incarceration, and for as long as the court can, under his guidelines. Thank you.
One moment. All right. Mr. O'Neill, is there anything you wish to say at this time?
Yes, Your Honor. I've had a couple of really rough years. I realize the court's aware of that. I was incarcerated last year in Otsego in February when I found out that I wasn't in remission anymore. The jail, when they were working with me, was working to do my tests on my liver for my necrosis and for my hepatitis B, for my tenofovir medicine. In September, when I was using heavily, and I have been using heavily, I was self-medicating. It's not the right thing, and I realized that. I was going through a series of tests. I just got done with a spinal tap from Mass Stations. Fear that it was going into my spine. I have a 25% chance of survival at this point in life. If I go through a bone marrow transplant, because I did deny it, she is correct, that leaves me at a 50% chance for graft-versus disease. I'm very familiar with this. It's basically where the stem cells either take or don't take in my body, and if they don't, then I'm on medication for the rest of my life that helps that. But I also have a 50% chance of my vital organs failing, my heart, my lungs, my livers, and thus my percentage goes down even further. So it's a very big gamble on my own life to go through with the bone marrow transplant at this point.
But it's okay to use cocaine?
No, it's not.
Okay. Is it okay to drive to Udall Hills?
No.
Out in the middle of the woods and then bring it, and then of course have your cell phone taken by the agents, and apparently according to this, it's detected that there were sales and transfers going on. And you also said that you were, I noticed you, because I know where Udall Hills is. I ride my mountain bike out there a dozen times a summer. So if you live in Kalkaska, where you could have gone up 37 or 31, whatever, or 37 or 31, you were coming through Cadillac. And then you were up in Manton and you weren't on a major road at the time. Well, wait, it was a 16 road, I think.
It's 42.
42, yeah, yeah. All right, but anyways, keep going.
No, it does not excuse my usage at all.
No, it doesn't make me think that you care about it too much either.
I care very dearly about my sobriety at this point.
But you also violated bond by testing positive for cocaine too.
This is correct, Your Honor. I'm not denying that I had an addiction. I've been going through my Catholic Human Services. I've completed 2 other courses. I keep going and attending courses. I keep going to my AAs and my NAs. I've talked with Catherine about becoming a peer support at this point, working with CHS myself, which is something that I very much would like to take my time to do, is to help other people realize, there's a better course out there. My actions have definitely stunted my life. I used to think to myself, I'm dying, what wouldn't you do? But now I think to myself, what wouldn't I do? I wouldn't give up the time that I have, not to spend with my daughter to fix my van for her to travel around the country as she wants to, working for the Parks and Recreation. I wouldn't give up the time to spend with my dog before she dies. I want to give up the time with my 15-year-old son to watch him grow. I want to give up the time that I have left, which is finite, to sit in either the county or in the prison system where I'm doing no positive anymore. I understand that what my actions have caused.
You haven't been doing positive out here so far. How much was that stuff worth, Mr. Bennett?
I was told it's approximately $100 a gram, so about 16,000.
So let's say it's even half of that. One of the first things you said to the agents or the officers when they pulled you over is, "Oh my gosh, my medical bills are $750,000 of $1 million."
I was using definitely in duress at the time and using that as sarcastic humor. It was taken very not lightly, and I can't change the fact that I said that.
Yeah, but you're willing to, and you, something about helping your daughter on a vehicle? What was this about?
No, these are things that I won't be able to do.
Right, well, using anywhere from $8,000 to $16,000 on your cocaine habit, if it's just a habit and you're not using to pay for, you're not selling it, which by the way, the evidence suggests that you are. You can see I'm not really buying a lot of what you're saying today, other than your health issues. I'll accept that. I don't have any records telling me all that, but I'll accept it. So anything else, sir?
No, Your Honor, I'm at your mercy.
Well, I feel really bad for you on your health issues, but I'm not going to let that cloud my sentence today. Because you do. Everybody else here seems to gives more of a deal or more of a care about your health issues than you do. So I'm not going to. All right. You don't want to take the treatments, don't get the treatment. If you don't want to go get help from addiction, don't get help. If you want to go out there and try to tell people that you're able to spend $15,000, $16,000 on cocaine out in Udell Hills. By the way, if no one knows where it's at, it's out past Wellston, it's out in the middle of nowhere. It's out by Big M. No, cocaine's on the rise in this community, and I think you're dealing it. And I'm going to tell you, anyone who's dealing drugs in this county, in this area, needs to go to prison. So, you had 5.7 ounces. Breaks down to 161 grams. When I look at CFJ 284A, page 5, when asked if he was trying to make more money, the defendant said, quote, "It's me, just, moving one thing to another. I came from a place on Udell Hills in the woods, but it's not where I was going with this." I can't make hide or tail of that. Now, by the way, I have no idea why you weren't charged with operating under the influence. You should have been. Why? Because you even said, "I'm likely to test positive." moment. So I'm going to go back and review this a little bit more thoroughly. A lot of this report was spent talking about your health issues, and I'm very, very sorry to hear about them. But I'm not going to give any more care or concern to them than what I've seen here from you, because I see that you have just tossed in the towel. You violated my bond by testing positive for meth. You're 42 years of age. You should know better. You traveled all the way down from Kalkaska down to Udall Hills, which is west, again, as I said, west of Wellston. Actually, that would be over in Manistee County, actually, by that point in time. So you travel from Manistee County through Wexford County, potentially on your way to Kalkaska County. It's definitely indications that you are transporting a large amount. I think there's definitely evidence that you intended to sell, which means you had a possession with intent to distribute. And why? Because of the information contained here in the report that says the extraction of your cell phone, quote, revealed several messages to and from the defendant indicative of drug sales. So here is a person dying from cancer who decides to throw in the towel, use it a lot, and according to this, by preponderance of the evidence, distribute it and poison other people. Yeah, you may have snowballed, and that's kind of an ironic choice of words. Everybody else, not me. So 5.7 ounces. Oh my gosh. Kind of makes me wonder where you got the $16,000. Now, I'm not here to ask a lot of questions. And by the way, I would have scored an extra 13 points. I would have scored them additional points in OB 13. Why? It's a pattern of 3 or more acts of felonies. You had this felony or prior to the other felony, and then you had a use, but that use could have been considered a possession, which could have also been a third felony. So you would have scored even higher points. You've already maxed out your offense variable points. And you were on parole or probation or parole for exactly the same thing. Now here's something else. I look back at your criminal history, and I know you have a 10-year gap, which means some of these things aren't counted on your guideline scoring, but you have this tendency to do what you want when you think no one's going to get away. You're going to get away with it. You're not going to get caught. I look at these little offenses, driving license suspended. You had what, I think 6 of them. You don't care if you got a rule that you're not supposed to. You're going to do what you want. You had a handful of these, a couple no insurances, putting people at risk. And then you start getting into marijuana in 2011. You picked up another drug case in 2019, but because you had a diversion program and you successfully completed that, that was dismissed, but sure enough, it's a drug case. Then you pick up another drug case a couple of years later in 2024. This is the one where you pled to a use, but it could have been a possession. You can't use without possessing. So that would have been your 3rd felony in a row here. You made it 4 months later and you pick up another cocaine case. And then after that case was done, you picked up, or after your sentence, you made it 5 months here. And after you were released on bond, you made it about a month. You are a danger to yourself. You don't care about your health issues, or maybe you do, but you toss in the towel. And maybe you want to spend time with your daughter or your son. You can't do it if you're high, and you can't do it if you're spending all your money. Pain. Now let's take a look here at something, because when I look about this month, the value of the cocaine, to look at your history of employment. I want to know where are you getting your money to pay for your cocaine? What was his last job, Mr. Van Atmel? Wasn't it at a hotel?
He ran a food truck and he's had several jobs as a chef.
Okay, when was the last time he was employed? On a regular basis, not just for a month or so, a regular basis. Probably would have been in his last PSI. I'm going to look at his employment history. He's been on Social Security disability since 2021. He's been living on disability, and he receives $1,280 a month.
In addition to that, he supported operating a food truck.
But it says here that it started in 2015. All right, but that ended in 2023 because he got a new job, but I don't know what the new job is because it's not listed on here. And plus, he's no idea where he's getting his $16,000 worth of money, or he's dealing. Where'd you get the drugs in Udall Hills?
I didn't get the drugs in Utah Hills, Your Honor.
Oh, what were you out in Udall Hills doing?
I was visiting a friend out there. There's a,
Why, it says you were moving. You were moving from one place to another.
traveling, yes.
All right. Well, let me also take another look here.
And if I can speak to my employment.
Yeah.
I own two different food truck companies.
Okay.
The one that stopped in 2023 was Uptown Dogs. I'd started the Mac Attack, which is a gourmet mac and cheese business. And I operate here in Cadillac area as well as Traverse.
Okay. All right, well, let's take a look here. Also to stop. You lied to law enforcement 1, 2, 3, 4 times. Oh, I don't understand. I don't believe a word you're saying. You have a pattern of dishonesty. You lied here to the police several times. I don't believe really anything you've had to tell me today. Yes, definitely looks like you're distributing. Well, I don't. Well, I have some relative. I only have a little bit of information, and that talks about the phone messages on CFJ 284A, page 5. So, plus an operating while under the influence. You are a danger to the community. You are a danger to yourself. Find that there are reasonable grounds for a period of confinement. I also find that there are reasons to support the sentence. By the way, it used to be that an intermediate sanction cell had a cap at 1 year. Then they changed it and said there is no more cap, but you have to have reasonable grounds. Once I find reasonable grounds, I'm no longer capped at 1 year. Court sentences the defendant as follows: $68 state minimum fee, $130 crime victims' right fund fee, a $300 court cost, since he can afford it, a $5,000 fine, a $300 attorney fee. Do we have a DNA, or was it already available? I assume it was already available.
Correct.
No DNA fee. I'm not going to place the defendant on a period of probation. Therefore, there's no probationary period. The court exercises its discretion to sentence the defendant as a second or subsequent drug offender. One moment. Which allows the court to double the sentencing guideline range. The maximum here is that 96. That's what the is that what
Enhancement.
that is with the enhancement?
Yes, Your Honor.
All right, so the court sentences the defendant within the doubling of the guideline range to a prison term of 24 to 96 months. and the defendant receives 102 days of credit. That is extremely within the guidelines and almost right there in the middle. I find that that sentence is reasonable proportion for the reasons and terms that I discussed. Mr. Harrison's going to bring to Mr. O'Neill 2 copies of one document. He's going to place his initials, Mr. O'Neill, you will, on page 1. Doing so neither elects nor waives in your rights and merely acknowledges receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal if you've been convicted at a trial. However, based upon the pleas in the case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Also, somewhere in here, I'm hoping that you'll get clean, you'll stay clean, and maybe live longer. Anything else, Mr. Van Appel? Ms. Carey?
No.
Thank you.
Okie dokie, let's go to Florida. Wade Mercer is just starting his first appearances.
Case, we do have Mr. Ricardo. Good morning, Mr. Ricardo. First case, Mr. Ricardo, I'm not sure which case you're here on, actually. Can you tell me?
Yes, Your Honor. I was requested for Javier Sobrino.
Okay, Javier Sobrino. Mr. Ricardo, if you'd please introduce yourself to Mr. Sobrino and make sure that he can see and hear you.
Señor Sobrino, mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Perfect. Mr. Sobrino, you're here because you've been charged with 1 count of driving with no valid driver's license.
Señor Sobrino está aquí porque tiene un cargo de manejar sin licencia de conducir válida.
Mr. Sobrino, I have read the complaint and there is probable cause for the charge.
Señor Sobrino, leí la denuncia y hay causa probable para el cargo.
Mr. Sobrino, you're entitled to a bond as far as I can tell in this case.
Señor Sobrino, hasta lo que yo puedo identificar en este caso, usted tiene derecho a una fianza.
But your criminal history does reflect a prior issue with immigration about 2 years ago.
Pero sus antecedentes muestran que tuvo una situación con inmigración hace como unos 2 años.
So I'm going to ask the jail first, have we heard anything from immigration in Mr. Sobrino's case, Sarge?
I've not gotten a response yet. I notified them this morning, but no response yet.
Primero le voy a preguntar a la cárcel, hemos escuchado de parte de inmigración en cuanto al señor Sobrino. Todavía no hemos escuchado de parte de ellos. Esta mañana les notificamos, pero todavía no nos han respondido.
So, Mr. Sobrino, your first option is for me to set you a bond this morning.
Señor Sobrino, la primera opción que tiene es que yo le fije una fianza esta mañana.
If I set you a bond, your bond will be $2,500 cash or surety.
Si le fijo una fianza, la fianza serían $2,500 en efectivo o mediante un bono de seguridad.
And you would be able to post that as of noon today.
Y podría pagarla a partir del mediodía de hoy.
What that means is if the United States Immigration Service chose to place a detainer on you before noon today, Central Time, we would have to honor that.
Eso significa que si el Servicio de Inmigración de Estados Unidos decide darle una orden de retención antes del mediodía de hoy, hora del centro, nosotros tendríamos que cumplir con eso.
Your second option is if you would like to resolve the case, I'm going to make you the following plea offer subject to the state's approval.
La segunda opción, si usted desea resolver su caso, le voy a ofrecer el siguiente acuerdo que queda sujeto a la aprobación del Estado.
Mr. Mitchell, any objection to the plea offer that was in the text this morning?
Go ahead, Mr. Ricardo.
Señor Mitchell, ¿alguna objeción al acuerdo que se ofreció y se envió mediante texto esta mañana?
I did have a question regarding it, and I don't know if I missed a typo or something.
Responde el Estado, tengo una pregunta, no sé si fue que malentendí algo.
Was it 10 days jail with a $400 purge?
Yes.
Okay, I read it as a 10 days with the fine. That's what I read it as.
Son 10 días, lo que se le ofrece son 10 días en la cárcel con $400 de purga. Sí, señor. Y bueno, lo había entendido diferente.
So if you wish to plead guilty or no contest and resolve the case, you can do that also.
Entonces, señor, si desea resolver el caso declarándose culpable o no me opongo, puede.
If you enter a plea of guilty or no contest, you'd be sentenced to 10 days in the Jackson County Jail.
Si se declara culpable o no me opongo, se le condenaría a 10 días en la cárcel del condado Jackson,
But you would be able to be released by paying a purge of $400.
pero pudiera quedar en libertad pagando una purga de $400
And the case would be over.
y el caso terminaría.
Similar to the bond, though, you would not be released until noon today.
Similar a lo de la fianza, no se le dejaría salir hasta el mediodía de hoy.
So you get to pick whether you would like to post the bond and come back to a later court date,
Entonces usted puede decidir si desea pagar una fianza y regresar en el futuro a otra audiencia,
or enter a plea of guilty or no contest, in which case I would sentence you to 10 days in jail with a $400 purge.
o declararse culpable y no me opongo, y en ese caso yo lo condenaría a 10 días en la cárcel con una purga de $400.
Do you have any questions about that option?
¿Tiene alguna pregunta acerca de esa opción?
Sí.
Yes.
Okay.
Bien.
Son 10 días en la cárcel y $400, o si pago los $400 saco.
So 10 days in jail and $400, or if I pay the $400, I'm released.
If you pay the $400, you're released from our hold.
Si paga los $400, se le deja salir de la detención nuestra.
So let's say that you enter the plea and you pay the $400, you'll be released at noon.
Así que digamos que usted acepta el acuerdo y paga los $400, se le dejaría salir al mediodía.
But only if the Immigration Service has not placed a detainer on you at that point.
Pero solamente si para entonces inmigración no le ha dado una orden de retención.
I have no idea if they will or not. I just see that they've been involved in your life before, it appears.
No sé si darán esa orden o no. Sencillamente veo que ellos han estado envueltos en su vida anteriormente, según parece.
Do you have any other questions?
¿Tiene alguna otra pregunta?
No.
No.
So do you prefer the bond, or would you rather enter a plea of guilty or no contest?
¿Prefiere la fianza o prefiere declararse culpable o no me opongo?
No me pongo.
No contest.
You do need to understand, if you enter a plea of guilty or no contest, you're waiving your right to a trial.
Debe entender que al declararse o culpable o no me opongo, está renunciando a su derecho a un juicio.
And you're also waiving your right to call and cross-examine witnesses at that trial.
Y también está renunciando a su derecho a llamar y contraexaminar testigos en dicho juicio.
Mr. Brunner, are there any other things you want to make him aware of before he enters a plea?
No, sir, Your Honor. Mr. McDaniel had met with him and he had indicated he wished to take the plea.
Ay, señor Brunner, ¿hay algo más de lo cual usted quiera ponerlo al tanto antes de que él acepte el acuerdo? No, señor, él se reunió con el señor McDaniel esta mañana e indicó que deseaba aceptar un acuerdo.
So, Mr. Sobrino, knowing all of that, is this the plea of no contest? Is that what you wish to do?
Entonces, señor Sobrino, sabiendo todo eso, declararse no me opongo es lo que usted desea hacer?
Sí.
Yes.
I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
I'm going to withhold adjudication of guilt and sentence you to 10 days in the Jackson County Jail.
Le suspendo el fallo de culpabilidad y lo condeno a 10 días en la cárcel del condado Jackson.
But you can purge that sentence and be released on this charge at any point before completing it.
Pero puede purgar la sentencia y quedar en libertad de este cargo en cualquier momento antes de completar la sentencia.
by paying the court costs and fine amount of $400.
al pagar la cantidad de multas y costas del tribunal de $400.
Mr. Sobrino, as I've said, you will not be released until noon today, even if you pay the court costs and fines.
Señor Sobrino, como ya le dije, no quedará en libertad hasta el mediodía de hoy, incluso si paga las multas y costas.
Lastly, court costs and fine purges are paid at the clerk of court's office, not at the jail.
Finalmente, las purgas de multas y costas del tribunal se pagan en la oficina de la Secretaría Judicial, no en la cárcel.
They have to be paid while the clerk's office is open, which is 8 a.m. to 4:30 p.m. Central Time.
Y tiene que pagarse mientras esa oficina de la Secretaría Judicial está abierta, que es entre las 8 de la mañana y las 4:30 de la tarde, hora del centro.
So, Mr. Sobrino, you'll be able to use the phone in just a few minutes to contact friends or family to try to make that purge.
Entonces, señor Sobrino, en solo unos minutos se le permitirá usar el teléfono para llamar a familiares y amigos y tratar de pagar la purga.
They can make it in person or they can make it over the phone with a credit or debit card if they wish.
La pueden pagar en persona o pueden pagar por teléfono con una tarjeta de crédito o débito si así lo desean.
If you want to make the purge out of your own money that you have at the jail will talk to you about the process to do that.
Si usted desea pagar la purga con su propio dinero que usted tenga en la cárcel le hablarán de cómo hacerlo.
Do you have any questions?
¿Tiene alguna pregunta?
Sí.
Yes.
So the clerk's question is, what happens if, Mr. Mitchell, if the Immigration Service places a detainer, if they do place a detainer on him at noon, what is the state's position going to be on a time served offer at that point?
I was just about to suggest that as you were saying it, I wouldn't object to it.
Señor Mitchell, si el Servicio de Inmigración de Estados Unidos da una orden de retención para el mediodía de hoy, ¿alguna objeción a que se le ofrezca tiempo ya cumplido? Responde el Estado, precisamente eso iba a sugerir yo, no tengo ninguna objeción.
So, Mr. Sobrino, you need to get your friends or family to be prepared to post that purge shortly, but right at noon, at 12 o'clock noon.
Señor Sobrino, entonces debe preparar a sus familiares y amigos para que paguen la purga, pero justo después del mediodía.
And if the jail tells you there is an immigration hold and you know that you're not going to be released, then my suggestion is do not post the purge.
Si la cárcel le notifica que tiene una orden de retención, que no lo van a dejar salir, entonces mi sugerencia es que no pague la purga.
Because if the immigration does place a hold on you, Mr. Mitchell's offer probably is going to be time served tomorrow and just go, and that'll save you the $400.
Porque si usted, si inmigración le da la orden de retención, entonces mañana el señor Mitchell le ofrecería probablemente tiempo ya cumplido, se iría con ellos y eso le ahorraría los $400.
Because if immigration is going to detain you, then you need to deal with that more so than this minor offense.
Porque si inmigración le da una orden de retención, pues tiene que lidiar con eso en vez de con esta ofensa menor.
Do you have any questions?
¿Tiene alguna pregunta?
Sí.
Yes.
Okay.
Bien.
¿Cómo lo puedo pagar yo desde aquí, del dinero que tengo aquí?
So how can I pay it with the money that I have right here?
Do you have $400 in cash or is it in some other form?
¿Usted tiene los $400 en efectivo o los tiene en alguna otra forma?
En efectivo.
Cash.
Okay. Sarge, I know there's a booking fee that comes out of his cash property. Is that correct?
Yes, sir.
Sargento, sé que hay un costo relacionado con pagar con su propiedad, ¿no? ¿Es correcto? Así es, señor.
How much?
¿Cuánto?
25.
25.
I couldn't hear. Did he say 25?
Yes.
Y no escuché, dijo 25. Sí, señor.
So, Mr. Sobrino, do you have at least $425 in cash?
Señor Sobrino, ¿tiene por lo menos $425 en efectivo?
Yeah.
So what I'm going to do is, if the Immigration Service has not placed a detainer on him by noon, Sergeant,
Entonces, sargento, lo que voy a hacer es, si el Servicio de Inmigración de Estados Unidos no le ha dado una orden de retención para el mediodía,
can y'all bring him to the courthouse with the $400 in cash so that he can post the purge?
Yes, sir.
¿pueden ustedes llevarlo al tribunal con los $425 en efectivo para que él pague la purga? Sí, señor.
If Immigration has placed a detainer on him by noon, I will just see him tomorrow morning.
Si Inmigración le ha dado una orden de retención para el mediodía, sencillamente lo vería mañana por la mañana.
Thank you, Sarge. Any other questions, Mr. Sobrino?
Y gracias, sargento. ¿Alguna otra pregunta, señor Sobrino?
No.
No.
Have a good day, sir.
Que tenga buen día, señor.
Thank you, Mr. Carter.
Thank you, Your Honor.
Ladies and gentlemen, we do have a couple friends or family here, so let me call those cases next. I've got the names a couple different ways on this next case. I've got Harrison Vargas, and then I have Harrison Velez Vargas, and the complaint says Harrison Velez. So I'm not sure which of those is accurate. So what is your correct name?
First name Harrison, last name Velez. Velez Vargas is both the last names. First and second last name.
Okay, so Velez would be your mother's maiden name, is that correct?
That Vargas, that would be Vargas. Velez is my paternal last name.
Okay, so you prefer to go by Mr. Velez, correct?
Yes, sir.
Okay, Jasmine is in the courtroom here. I want you to let you know she's here on your behalf. You're accused of one count of driving license suspended or revoked with knowledge. Mr. Velez, I'm going to appoint the public defender's officer to represent you, tell you there is probable cause in the complaint. I have read your criminal history. Listen to Mr. Blunt, your attorney for today's purposes, and we'll see where we stand.
Your Honor,
Okay.
it's my understanding Mr. Harrison Velez Vargas would like to enter a plea of no contest with the understanding, subject to your approval, he'd be sentenced to 10 days in the county jail with a purge of, is it 400? Is that what y'all, $400 fine? And that can be paid. Once it's paid, he would be released from jail. He would receive 1 day credit for this.
Mr. Mitchell, any objection to that?
No objection. That is agreeable with the state.
Sir, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
No, not at all.
And is that the plea you would like to enter?
Yes.
Okay, to the young lady in the courtroom, are you going to be the one making the purge for him? No? Okay, so whoever makes the purge, she doesn't know if she will or not. Whoever makes the purge for you, make sure they understand that it's got to be made when the clerk's office is open. The reason I tell people that is I don't want somebody trying to make a purge at 5 o'clock today. The clerk's office is closed. You've got to spend another night in jail before you can get out tomorrow. So make sure they go ahead and make it before 4:30 when the clerk's office closes. I would tell them before 4 o'clock. If I'm in jail, I'm gonna tell them, go ahead and make it now. Just be aware of that. Any questions before I accept this plea?
No, not at all.
I'm gonna accept your plea of no contest to the charge of driving license suspended or revoked. I'm going to withhold adjudication of guilt. I'm gonna sentence you to 10 days in jail, but you can make a purge on that sentence and be released immediately before finishing the 10-day sentence by paying court costs and fines of $400. If you make that payment at the clerk's office when they're open, you're gonna be released. So if the payment's made this morning, they will notify the jail by secure email that the purge has been made and you'll be released. If the payment's made in person, the clerk's office will get a receipt. Whoever makes the payment, they'll take that receipt to the jail and you'll be released. And if you can't make it for 2 days, then whenever you do make it, you'll be released at that point. Any questions, sir?
No, not at all.
All right, have a good day. Ma'am, do you have any questions? Any questions, ma'am? All right. Next case that has friends or family here, ma'am. I can't hear you. Do you need a what to get him out?
I'm from another state. I'm not sure if I need a license.
All you need is a receipt showing that purge has been made. So if you or someone's going to make that purge, they make it at the clerk's office, either in person or by phone. If it's made by phone with a credit or debit card, the clerk's office will send an email to the jail that it's been paid and he can be released. If it's made in person, they will give you, or whoever makes it, they'll give them a receipt showing it's been paid. Then you take that receipt to the jail and he'll be released. So as soon as it's paid, he'll be released. You don't have to worry about a license unless you pay it in person with a card. They may ask you to verify your identity that you're the person that has that card, but otherwise you don't have to have a license. The clerk's office is downstairs on the first floor on the east side of the courthouse. So you go out this door, Deputy Spates is in the back. He can show you where it's at. Okay. Hey, ma'am, this paperwork here, are you going to try to go down there and try to pay it?
To get information if I can.
Okay, this is his disposition. It's got the amount on it. Next case, it has friends or family here is Desmond Baker.
Baker.
Mr. Baker, good morning. Mr. Baker is very tall, Sarge. We're going to need to address that camera up, please. We can see Mr. Baker. There we go. Mr. Baker, good morning. You're here because you've been accused of one count of aggravated battery. Mr. Baker, there is probable cause in the complaint. Mr. Baker, I have read the complaint. I've also looked at your criminal history, and it appears to me that you're out on bond in case 25437. Mr. Mitchell, is that what you show?
That's what I showed too.
So, Mr. Baker, even though I think you're entitled to a bond, you very well may be held without bond in that case. The other case, we're going to see what happens in just a moment. Mr. Mitchell, anything from the state?
I have been provided information from his stepfather regarding both the bond situation and this new case, if you're okay with me saying that.
And I apologize. I meant to tell you your stepfather's in the courtroom and I forgot. Go ahead, Mr.
So according to my conversation with his stepfather, they have already been in contact with the bondsman about keeping him on bond. Additionally, I was provided a sheet of paper by the alleged victim in this case, and I believe our victim advocate has also been in contact with the victim, talking about how, you know, she may be wanting to have these charges dismissed. I know that he's charged with a second-degree aggravated battery, and this happened after he was on bond. So we'll just leave it up to the court to determine whether or not his bond should be revoked in 25437 CF, given those circumstances.
Thank you. Mr. Blunt.
I did have the opportunity to, when his stepfather came in, he had a letter that was signed by the alleged victim. It was addressed to Mr. Larry Bashford in his office, but based on the situation, I did read the complaint. Your Honor, I would ask that the court allow him, set him a reasonable bond on this with the understanding that the victim is not wanting to pursue charges, and allow him to remain on bond in the 23 case number.
Okay. So, Mr. Baker, the complaint alleges she told law enforcement you hit her with a 2x4 at least twice. So the question is, are there any injuries to support that? And I'm going to read from the complaint here. She advised that Desmond Baker pushed her to the ground. Victoria then stood back up and kicked over a cooler, being upset. Victoria further stated that Desmond Baker continued to escalate the incident by grabbing a 2x4 wooden board and striking her once in the abdomen and once on the left side of her head. Photographs were taken of Victoria Hewitt's injuries, which are consistent with her account of a physical altercation. So since there appears to be injuries consistent with the account, then I'm going to revoke your bond. It's a no-brainer to me. You're accused of a second-degree felony while you're already on bond. So I'm going to set your bond in the new case. Don't get confused, though. Even though you're getting a bond in the new case, $15,000, don't try to post it, because I'm revoking your bond in the case you're already out on bond on. I think it was a drug offense, and it's pretty recent. He's on bond in 25437, and in that case, I don't know why I'm thinking it was cocaine charge, because it was. Possession of cocaine and principal destruction or tampering with witness. So in 25437, I'm revoking your bond. This is not the bonding agency's choice. They have no input at all in this. The question is, have you committed a crime while you're on bond, or is there evidence you've committed a crime? And is that evidence concerning enough to a judge to revoke your bond? And it is. So you have no bond in that other case. Now, let me tell you what happens. The state attorney's office will get the new case, Mr. Baker. If they decide they're going to dismiss that new case, Judge Garcia very well may say, hey, since they're dismissing the new case, I'm going to reinstate your bond. That may happen. But right now, considering the allegations against you and the evidence against you, you've got no bond in the case you're already out on bond on. Mr. Baker, do you have any questions?
No, sir.
Sir, do you have any questions in the courtroom? Any questions? Any questions? Wish you the best, Mr. Baker. We do need to give you a court date for Judge Garcia, and that would be February 3rd. February 3rd at 8:30 would be his court date, please.
Do you need a proposed order?
Yes. Okay. Yes. I need an order unless the state is deciding to drop the charges today. If y'all look, I don't know that you'll even have it.
Yeah, it's too early.
I would think it'd be too quick. So
Yeah.
if y'all need time to look at it, send me an order revoking his bond, and then once y'all make y'all's charging decision, we'll go from there.
Okay.
All right. So wish you the best, Mr. Baker.
Thank you.
That takes care of everyone that has friends or family in the courtroom. And guess what? 15,000. And the condition, no contact with alleged victim. Mr. Baker, you've got a condition of no contact with alleged victim. Sarge, please make sure he knows that's a condition that's required by law. At least.
Yes, sir. He's right here.
Yes. Thank you. So that takes care of everybody that has friends or family here, I believe. Let's go back to the top of the docket. I know I have a 9 o'clock hearing, Mr. Green, Mr. Axon, but we have a bunch of first appearances, so we'll get to it as soon as we can. Samuel Mills is next. Mr. Mills, good morning. You're here because you've been accused of 1 count of grand theft motor vehicle. Mr. Mills, there is probable cause for the charge. I've also looked at your criminal history, and I think you're entitled to a bond as far as I can tell. Let's see if the attorneys have any additional information. Mr. Mills, Mr. Mitchell.
No, Your Honor.
Mr. Blunt?
No, sir.
Mr. Mills, your bond's going to be $5,000 cash or surety. It's a standard bond on this charge, sir, for someone that has criminal history at least. You've got a condition of no contact with alleged victim. So you cannot have no contact with alleged victim, but you do get to use the phone to try to post the bond. Cash or surety means you can put up all of it if you wish, or you can go through a bondsman. Mr. Mills, do you have any questions?
No, sir.
Mr. Mills, you're going to also be given a notice for your court date, which will be February 3rd. And I wish you the best. You'll get to use the phone shortly, sir.
Thank you, sir.
Yes, sir. We have Keon Hamilton. Mr. Hamilton, good morning. Mr. Hamilton, you're here because you've been accused of 1 count of misdemeanor domestic violence battery. Mr. Hamilton, there is probable cause in the complaint. You have 1 prior charge on your criminal history, but it's not the type of charge that would prevent me necessarily from giving you a conditional release if you have somewhere to go and live other than where the alleged victim lives.
Yes,
So
sir.
the alleged victim's relationship to you, the person that's accused you of this, is what relationship to you?
It would be my sister, correct? I'm not sure.
I'm not sure if it mentions niece, it mentions siblings. I'm really sure the person that claims that you threw water on them is a sister. Is that right?
Yes, sir.
Now, do you and that
Yes, sir.
person live in the same home?
Yes, sir. But I can leave.
You-
I can move. Yes, sir.
Where else would you go then? Where else
My
would you go
friend-
on a temporary basis?
My temporary, I could go to my great grandmother's house.
Is that in
like
Jackson
today.
County?
Yes, sir.
Okay, Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Blunt?
I'd ask for a conditional release, Your Honor.
Mr. Hamilton, I'm gonna let you pick between the bond and the conditional release. If I offer a conditional release, I always give a bond option just because some people prefer a bond. Your bond will be
Yes.
$2,500 on this misdemeanor charge. I am going to offer you a conditional release because of the allegations and your history. You do have a condition, no contact with the alleged victim, at least for the time being, which means
Yes.
you can't live in the home she's living in. Mr. Hamilton, do you know whether you prefer the bond or the conditional release?
Sorry, what exactly is conditional release?
Did Mr. McDaniel meet with you this morning?
Mr. McDaniel,
The attorney, the assistant public
Yeah.
defender?
he said he didn't want to talk to me.
Okay, so let me tell you what a conditional release is. A conditional release, well, let me explain a bond so you can compare the two. A bond is where you go through a bondsman or put up all the money. So in your case, it's $2,500. You either put up $2,500 or you go through a bondsman and they'll charge you a percentage of the bond to get you out of jail. That percentage is usually around 10%. In your case, that's $250. You do not get that back. If you go through a bondsman, that's the fee for their services. They have to vouch for your appearance. If you miss court, they have to pay the whole $2,500. That's how the bond works. A conditional release is different. A conditional release doesn't cost you any money to get out of jail. but there's a trade-off. The trade-off is a conditional release has more rules to follow than a bond. That's why that's the trade-off. It's cheaper, but it's harder to live by. So on a bond, you have 3 rules. In your case, don't miss any court dates, don't be charged with any new crimes, and have no contact with the alleged victim. On a conditional release, you have those same 3 rules, plus you have other rules. On a conditional release, you have to report into a conditional release officer once a week by phone. On a conditional release, you cannot possess or consume alcohol. On a conditional release, you can be drug tested. So conditional release has more rules than a bond has, and a conditional release is not free. It costs $40, $30 a month. So it's cheaper usually because you're not on conditional release. Usually in Jackson County, 1, 2, 3 months or so is usually the average. So it's usually cheaper so that you can choose the bond and it costs you more money up front to get out of jail, or the conditional release, which has more rules to follow. Any questions?
No, sir. I'll take conditional release.
We'll grant you the conditional release. They're going to let you use the phone before you leave the jail. Mr. Hamilton, you can tell your friends or family they can pick you up at the conditional release office, which is at the Jackson County Courthouse, inside the county judge's office, and you'll probably be there in 30 to 45 minutes to be picked up. Once the conditional release officer meets with you, you'll be free to go, okay?
Thank you, Your Honor.
Yes, sir. I wish you the best. Also, going to give you a notice for your court date when you get here, and that will be February 2nd at 9 a.m. Wish you the best, sir.
We are present this morning in the matter of State of Ohio versus Tyler, aka Talia Karen. This is case number 24 CR 1412, President Open Court. This morning is the defendant with her attorney, Rachel Smith. We were last here for a change of plea on October 23rd of 2025. At that time, the defendant withdrew her pre-sentence plea of not guilty, entered a plea of guilty to attempted aggravated arson, felony of the 3rd degree, and grand theft of a motor vehicle, felony of the 4th degree. This court set the matter for sentencing and ordered a pre-sentence report, psychological evaluation. Those are completed. We did appear for sentencing between that date and today a couple times. Both times, although we didn't go on the record, this court did continue the matter so that additional resources could be sought in regards to a potential outcome of this case for sentencing. Did have a chance to speak with defense counsel today and listen to the plan that's been presented. The state has also reviewed the pre-sentence report and psychological evaluation along with all the other documents presented in this case throughout the while this case was pending, and is prepared to proceed with sentencing at this time.
Okay. We actually are going to do sentencing first, and we'll address the registration afterward. Okay. So with that said, Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. On behalf of Ms. Karen, we are asking the court to impose a period of community control here. And Your Honor, we make that request without minimizing the seriousness of the offense here. Ms. Karen has pled guilty to setting fire to the home of her legal parents, and has been very forthcoming about her guilt in that regard from the outset. What is given defense counsel, and I believe this court pause and allowed the matter to be continued multiple times ahead of sentencing, goes a little bit deeper than the surface of the offense. Ms. Cran has a deep mental health history that the details of which I believe are currently being uncovered as this case has moved forward. Ms. Cran does have a history of seeking mental health treatment for PTSD, as well as several suicide attempts. And Your Honor, the impetus for committing the instant offense arose from pervasive and fixed beliefs that Ms. Karen has about her childhood and the role that her legal parents did play in that. Your Honor, Ms. Karen has no criminal history, did finish high school, is incredibly intelligent, has had no issues in the jail, She pled guilty to a felony of the 3rd degree and is in need of mental health treatment and is open to that treatment. In the past, Ms. Coran has been resistant to medications as part of mental health treatment, but she's expressed an openness and willingness to be medication compliant if medications are recommended as part of her treatment. Additionally, Your Honor, Defense Counsel has been working with Crossroads Behavioral Health representative, for which is present in the courtroom today, to facilitate Ms. Coran's admission into North Coast House. And it's our understanding that while at North Coast House, Ms. Coran's mental health needs will be taken care of, as well as wraparound services provided.
As well as what?
Wraparound services provided. Your Honor, we do believe that with the proper treatment and assessment, so long as Ms. Karen is willing to participate in that, will help to remedy the cause of what brought us here today. We don't believe that the public or Ms. Coran would be made safer if Ms. Coran is sent to a prison and without treatment. In fact, it's likely that her issues would become worse and she would exit prison on some date a greater danger to herself and to the public. And Your Honor, for those reasons, as well as those that have been discussed throughout the pendency of this case, we are asking the courts to give Ms. Coran credit for the days that she served in the jail, to grant her community control, and allow for her to participate in the program at North Coast House for mental health. Thank you.
In regards to North Coast House, we've chatted in chambers about this. My understanding is, based on our conversation, they don't put a time period in place, though I was advised it would be at least 90 days. Can it be longer? And when I was advised it could be, but can I order a certain amount of time for that, or is that up to North Coast House?
Your Honor, I was able to ask Mr. Dials prior to coming on the record that very question, and he indicated that they would be able to comply with the court. If the court were to order a period of time, they would be able to comply.
What is the technically at the range we're talking? I mean, what time periods could someone be there? Why don't you state your full name, please, for the record here?
Jamie Dials, Director of Forensics with Crossroads Health.
Is that D-I-A-L-S?
D-I-A-L-S.
Okay.
So we've never had a situation where an individual was court ordered to a specific amount of time. Typically, the stay is 90 days. However, it's not uncommon for Crossroads Health to extend that time for various reasons until they maintain some form of mental health stability or until they find more long-term housing options. So in short, yes, we could honor.
What's the longest time someone stays there?
I
know there's no written rule on that regard, but in terms of if someone had the need that, the need that to be there, how long would you keep someone there?
So for example, I also oversee Lake County Mental Health Court, and we've had individuals in North Coast House. And as a service, they would extend people's times there in North Coast House because of the immediacy of mental health court. I would say the longest that I'm aware of is probably close to 9 months.
Okay. Appreciate that. Member Smith, was there anything else? I'm sorry.
I don't believe so.
Ms. Karen, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
No, sir.
Well, there's a lot of people that put a lot of time and a lot of effort into trying to get you help instead of the alternative. Is this a waste of their time?
No, sir.
If I was to give you this chance, are you gonna take it seriously? Are you gonna work the program? Are you gonna put forth the effort? Or is this just a way to avoid prison?
I will follow the program, sir.
The program requires that you take all medications as prescribed. Are you gonna do that?
Yes, sir.
Is that gonna be an issue?
No, sir.
Do you want this treatment program?
Yes, sir.
Do you want this help?
Yes, sir.
It's gonna take some work on your part. It's not
I
just gonna
understand that.
go there and everything's better, you know that. I know you know that. You're willing to put in that effort and the work?
Yes, sir.
And this is a big ask you're making here, or through your attorney, with the nature of the charges here. And Smith, anything else?
Your Honor.
Mr. Downey for the state of Ohio.
Thank you, Your Honor. Before I say anything on behalf of the state, the defendant's parents, who are also the victims in this case, are present, and one or both of them would like to make a statement to the court. So
Absolutely. And you could stand right there, sit whatever you're comfortable doing. State your full name, please, and spell the last name so court reporter can get in. Take your time and tell me whatever you'd like me to know.
Cheryl Karen, it's K-A.
Stan, can you get a microphone, please? Hang on one second. You can just hold it down low. You don't need to talk right into it, but.
Test.
Yes. Yeah.
Cheryl Karen, it's Karran.
Go ahead.
My husband.
Oh, yeah. What's his name?
Bentley, Karen, Karran.
Thank you both.
We just want you to know that we love Talia. This isn't behavior that we ever expected. And we support any help that she can get. We appreciate all the effort that everyone has made to help this happen. I don't believe that prison is going to help her at all. And I really think that Ms. Smith has been amazing. Sorry. She's been really amazing at really working to get Talia the help that she needs. And we just want her to know that we love her and we'll always be here for her.
Just Karen, anything you want to add? You don't have to. I just want to make sure. Okay. Thank you. Thank you both. One second, Mr. Downey. Mr. Downey for the state of Ohio.
Thank you, Your Honor. Clear that the defendant here is suffering from significant mental health issues that need to be addressed, and from the mental health side and the diagnoses that have been presented through evaluations and the hospital records, it does appear that the treatment plan presented here does appear to address those issues. I think the difficulty for the state has been that the defendant also separately realizes that she committed a serious crime and that crime was retaliatory in nature and unprovoked in the moment. She says in the pre-sentence report that she purposely went to the house to confront her parents, that after conversations with the parents, she was unsatisfied by their responses. She declined to leave the residence, and then waited till they were gone and decided to set fire to the home when there was no active threat against her at the time. At the time the pre-sentence report was completed, it did not appear that she had remorse for her parents. It would seem to be more remorse that she was caught and now in the criminal justice system. And even if the defendant's delusions here were in fact true, her conduct would never be justified. So certainly not legally, which is why there's not a legal defense here, but also morally. So it's, from the state's perspective, what she did is just straight up criminal conduct. So I guess where the state struggles is then what is appropriate here, because her parents, the victims, want treatment. They've been extremely understanding and forgiving from the very start of this case when I first had contact with them. And I think that prison would certainly be justified here. I mean, the crime is serious. I mean, just the reduction here that the state gave to a felony 3 is pretty significant given the damage that was caused here. I mean, their home was destroyed and has to be completely rebuilt. I mean, hundreds of thousands of dollars of damage. If the defendant were to go to prison, she served a little over 9.5 months here. So the court has roughly 44, give or take, months to play with here for prison is what she'd be looking at, considering jail time credit.
Like 38.
36 from the felony 3 plus 18 from the...
Oh, I forgot about the other charge. Sorry.
And considering what was just said here today about North Coast House, I know I'm making a couple assumptions here, but she goes there and does treatment for 9 months where she's in a facility where she's not out in public. We're talking about, roughly about 3 years is what, if she went to prison, it'd be 3 years that she's away from society, right? So what is the right recommendation here? Prison for 3 years where we know that she is going to be away from society and is not going to be a danger to those around her. But in no way am I jaded and thinking that she's going to get the appropriate treatment in prison. And arguably, she might come out worse. However, given the nature of this offense, prison seems like the appropriate sentence from a punishment aspect. So the mental health professionals and the treatment professionals that are here who have been involved in this case, they appear to be confident that the defendant can receive treatment that is adequate to not only treat the deep mental health issues, but also protect the defendant and those around her, in the sense that if she receives this treatment, then she will not commit further serious criminal conduct of this nature. And I'm not a mental health professional, so I have to defer to them, I think. Both of these options here, I think, seem pretty even when it comes to pros and cons. And the issues that the defendant has today that I think led to this seem to be something more recent. She has led a law-abiding life for a majority of her life. Best we can tell from looking at records and timelines is that at some point, this offense happened October 2024. At some point after January 2023, so about a year and a half, almost 2-year period, is when these more serious issues develop. So in terms of the defendant's entire life, this is something that's more recent. And when the defendant didn't have these issues or was receiving treatment or whatever she was doing before, she was safe and wasn't a dangerous society. So based on what the mental health professionals have said, I have to think that if she were to get adequate treatment, that she would go back to that state. And from the start, the state has indicated that it would be amenable to treatment if an appropriate treatment plan was presented. So I'm going to go along with the joint, or with the recommendation of community control, make that joint recommendation. I do so with a lot of hesitation. I know ultimately it's not up to me, it's up to the court. But I think the treatment plan should be done so with the understanding that if the defendant does not follow the treatment plan, then there will be very quick and serious consequences, which would be the termination of her community control in this case. I don't believe there's any restitution submitted from the victims here. The defendant does not have any money anyway, and given that it's her parents, I have not received any information from them about that. And so there's nothing further from the state.
Thank you. Well, I've considered the pre-sentence report investigation, the psychological evaluation. I received other evaluations that were done throughout the pendency of this case. There was a evaluation for NGRI that was done. We've had several hearings scheduled where we've talked and discussed this and continued the hearing to get more information. All that's being considered by this court. The victim impact statement, I read and considered that. I've considered everything said here today by all the parties who addressed the court. I have considered the particular facts and circumstances of the offenses involved and the nature of those offenses, and I've considered all this in light of the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912 indicating it's more serious, the court notes that the defendant's relationship with the victims facilitated this offense. The victim suffered serious psychological harm as well as economic harm. And then other relevant factors, I mean, this destroyed their whole home. Most arson cases we have don't cause the damage that was caused here. You know, someone lights a small fire, there's a little bit of damage. That's what we typically deal with in an arson case. That's not what most people think about when they think about arson. They think about what happened here, quite frankly. But that's not the normal arson case. That's what we have here. As the prosecutor mentioned, it was retaliatory in nature. It was unprovoked. Those are all factors indicating it's more serious. Nothing makes it less serious. As for recidivism factors, the court notes there's no genuine remorse. It hasn't been shown. It hasn't been shown in the pre-sentence report. And she feels bad for her parents, but then she immediately turns it around. And I know there's the mental health issues that are in play here. When she starts talking about the reason why she did this, and there's no remorse in that part of it. There's no remorse here. And given the chance today, I mean, she doesn't have to make a statement, but she didn't, and she didn't display any here today either. Factors indicating recidivism is less likely. There's no prior criminal history here at all. No juvenile delinquency adjudications, no convictions as an adult, led a law-abiding life. Her entire life up until this. Other relevant factors indicating recidivism is less likely. I don't know if it indicates recidivism is less likely more than, I mean, obviously the mental health issues play a significant role here. If they can be addressed, then the hope is that would lessen the chance of recidivism versus the defendant just being a bad person. I mean, obviously there's an argument that there's significant mental health issues that could cause there to be recidivism could be more likely in the future. But with treatment, hopefully that can be addressed. The lesser included offense here of count 1 is a felony of 3rd degree. There's no presumptions one way or the other. Prison certainly is consistent with the purposes and principles of sentencing when you look at the nature of the offense involved. And that's been the court's struggle here, and that's, you know, again, a lot of what the prosecutor said, the court's been struggling with those same issues in terms of just the nature of the offense itself. But due to the significant mental health issues that are in play here, though they don't amount to a defense, they certainly are relevant, are genuine, are significant. Also taking into strong consideration the victim's desires here, the court will find the defendant's amenable to an available community control sanction. I'll give you a chance, but you're getting one chance here. This is a big opportunity. You should hopefully view it as an opportunity, not a break, but an opportunity that you're being given here. And there's a difference there. If you view it as an opportunity, hopefully you work at the program, put forth the effort. If you view it as just a break that you got lucky, then we're out of luck. I'm going to put you on community control sanctions for a period of 3 years. I am going to order that you serve 6 months on the lesser included offense of count 1 and 6 months in the jail on count 2. I'm going to run those consecutive for a total of 12 months. You have credit for 286 days. So a total of 12 months in county jail. I'm going to order that you enter the dual diagnosis programming at North Coast House as soon as the bed's available, and then get you in. As soon as that bed's available, you can be released from the jail. The balance of that 12 months will be vacated. So I just did that amount, so we have enough time to get you there. My understanding is it's not that, won't take that amount of time. Is that correct, Mr. Niles? You're gonna enter North Coast House. I'm gonna order for now for a minimum of 6 months. If we get to a point where it's time to be discharged and there's nothing more that can be done, something can be filed with the court and I'll address that. But I'd like to put that in place now. Will that work, Mr. Dowles?
Yes, sir.
All right. To participate in the programming there, successfully ultimately complete that program. Further conditions, I want you to get a full psychiatric and psychological evaluation, follow recommendations. So recommendations for medication, Whatever medications are recommended, you need to follow those recommendations and take that medication as prescribed. If you don't, we'll be back here for a violation. You understand that?
Yes, sir.
In terms of the psychological evaluation, follow all recommendations, which will include individual counseling, to include an EMDR therapy. I want you to participate in that. I want you to, further conditions, you're not to use any drugs or alcohol. That includes even marijuana. No marijuana use. Shall submit random urine screens when requested. They have to be negative. I want you to attend at least 3 AA meetings a week and have a sponsor. Ultimately, you're to obtain and maintain full-time employment or education. If you want to go to school, get some type of training, that counts as well. But on a full-time basis, you're ultimately going to be keeping yourself busy on a full-time basis, working or going to school or some combination of the two. You understand that?
Understood.
You're to utilize any case management services that are available with the treatment program for assistance and help, and utilizing the resources in the community. Pay court costs and supervision fees. Follow registration requirements that are going to be provided to you here in a moment. I want you to sign whatever releases probation needs from you so that they can contact counselors or therapists if necessary. So you need to do that. You're going to have one doctor that can prescribe you medication. If they're specialists, that's fine as well. But make sure probation knows who the doctors are that you're getting prescriptions from. You can go get them from those doctors. You can only fill them at one pharmacy as well. Megan, is there anything else I should be thinking about here, considering?
No, Your Honor, thank you.
Lisa, anything else?
No, Your Honor.
Your dials, have we covered everything we need to cover in terms of for the North Coast House there?
Yes, Your Honor.
Okay. Ms. Karen, do you understand all the conditions of your community control sanctions?
Yes, sir.
Any questions for me?
No, sir.
Need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, if you commit another criminal offense, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. Technically, I could impose more restrictive sanctions, including local jail time, or I can and will terminate your community control sanctions and send you to prison. If that happens, and that's what will happen if there's a violation, it'll be 36 months in the lesser included offense of count 1, an additional 18 months on count 2. That'll be consecutive for a total of 54 months in prison, which will also be consecutive to any other prison sentence that you may be serving for some other case, if some other case happened, or that you're being sentenced to at that time. So do you understand all that?
Understood.
Do you have any questions for me?
No, sir.
In terms of sentencing, I know the registration, anything else that we need to address, Mr. Downing?
Yes, Your Honor. The victims indicated that they don't want a no contact order. They want to be able to speak with the defendant, have contact with her. However, they don't want her at their residence, either the residence in this case or the one, whichever residence they're currently staying at.
So you are not to, and I'll grant that as a condition of probation, you're not to go to your parents' residence, either the home where this happened or the home that they're currently residing at. You can have contact with them in terms of phone calls, letters, emails, texts, even seeing them if they come, but you can't be at the house. Is that what you're requesting? be at the house, can't be where they're residing, you understand that?
Understood.
Ms. Smith, anything else as far as sentencing goes?
Not at this time, Your Honor.
All right. Well, Ms. Karen, I need to advise you at this time, as you were told at the time of plea, you will be required to register as an arson offender. And I need to advise you of what those requirements will be. And then I'm going to have you sign this document indicating that, acknowledging I read them to you and you understand them. You don't have to necessarily agree with it, but you're acknowledging I read it to you. You're going to get a copy of this. So I'm not expecting you to memorize what I'm telling you, but I'm required to read it to you. So I'm going to do that at this point. So, do you have a middle name? Do I have that, or is that?
Legally, yes. Alexander.
I guess not.
Your Honor, the legal middle name is Alexander.
Alexander. I'm going to put that on here just for the form. And I'm going to use the address, expected residence address. I'm going to use North Coast for now. What is that address, Mr. Downs? You know, we don't know.
Sorry, I don't know. I know it's in Concord now.
Nobody knows this address?
The 255 Center Avenue is wrong then?
Correct.
Okay.
Used to be.
I thought, that's just the Menor Avenue address.
It's moved from Menor Avenue recently. I can find out.
How can you find out? Just the texting somebody? All right. Then I'm going to go with these, and then we can just add that after. So I'm going to, your expected residence address, I guess at this point, is the North Coast house, correct? And
Understood.
after that, you don't have any plans at this point as to where you expect you would be residing, or do you?
No, sir.
Well, we'll use that address for now, and we'll give that, I'll get that here in a moment. But let me read you the requirements, your obligations you're going to have. You've been convicted of, pled guilty to an arson-related offense. You will be required to register in person with the sheriff of the county in which you establish residency within 10 days of being released from incarceration, or within 10 days of your sentencing hearing, if not sentenced to incarceration. So since you've been sentenced to incarceration, once you get out, you have to register with the sheriff's department within 10 days. That is at 84 North State Street in Painesville, and I'll read that to you later as well, and you'll have that, but that's where you're going to need to go to register. You will be required to provide the sheriff certain information, which will include your social security number, your full name and any aliases that you use, your residence address, information regarding the offense which you were convicted of, any description of any scars, tattoos, or other distinguishing marks on your person, the name and address of any place where you're employed or attend school, any driver's license number, commercial driver's license number, or state ID card number issued to you, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle information number, and a description of the vehicle must also be provided to the sheriff. You'll be required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of your registration. You'll be required to remit a registration fee of $50 to the sheriff unless that fee is waived. After the date of the initial registration, you'll be required to re-register annually. You must update and/or amend any of the information described above that has changed, and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially registered. If you are registering in a different county than your prior registration, you must provide notice of your change of address to the sheriff with whom you most recently registered. You will also be required to pay a re-registration fee of $25 to the sheriff. Now I'm going to waive the initial $50 registration fee, and then the $25 re-registration fee. At that point, you should be working, and that should be assumed should be all right. So put in the entry that the Initial registration fee of $50 is waived. Now, you'll be required to comply with all the above described requirements until your death, unless your sentencing court determines otherwise. Since your expected residence address is in Lake County, you'll register in person no later than 10 days after you're released from jail with the Lake County Sheriff's Department at 84 North State Street, Painesville, Ohio, 44077. Your failure to register or failure to verify your residence at the specified times will result in additional criminal prosecution. You understand that?
Understood.
All right, do you have any questions at all about any of these registration requirements, what you're going to have to do?
No, sir.
All right, then I'm going to hand you this form right now. In line 10, it reads, I acknowledge that these requirements have been explained to me. I understand the requirements and I must abide by them. And then I have you sign this again. It's acknowledging you understand it. So in line 10, I'm going to have you place your signature.
Your Honor, I have that address.
Get that back to me for 1 second, Stan, please. Let's get that on there first before she signs. What is it, Mr. Downs?
7480 Auburn Road, Concord Township.
44077 there, I think?
Yes.
Is there a phone number, or would that be the 241 number, or is that not? You don't know? That's all right.
Okay.
That's all right. All right, here you go. Mr. Karen, you signed the document?
Yes, sir.
I'm going to place my signature on line 11 now that reads, I certify I specifically inform the offender of her duties as set forth above, as you indicated. To me, in understanding those duties, I place my signature. We'll have the bailiff make multiple copies. We'll get you a copy, your lawyer, the prosecutor, sheriff department. I think that covers everything. Mr. Downey, is there anything else that we need to address or should discuss?
So for the judgment entry, I was just putting there that the defendant was advised the arson offender registry acknowledged signed up in court, initial $50 fee waived. Is there anything else the court wants specific for that?
Initial $50 registration fee.
Correct, yeah.
It's hereby waived. No.
Thank you.
I did make that a condition of community control also to register.
Yeah, thank you.
Ms. Smith, anything else?
Not at this time, Your Honor.
All right.
All rise.
Jennifer Marie Ashby, 25W838597, LVMV versus Hageman will be next. Your name, ma'am?
Jennifer Ashby.
Where you been?
I was unaware of the warrant. I had some arrest.
Did you get your ticket?
I didn't get anything. I believe that.
Hang on a second. You got written for impeding traffic. The officer handed you the ticket.
No, I was not driving my vehicle. I believe it was my roommate that was driving the vehicle upon the ticket. And she lives with me, so I didn't receive any mail, and I was pulled over and they said there was a warrant for my arrest. So I'm here today.
This wasn't you driving?
No.
Well, I can't, listen, here's what I can do. Can you post $237?
No, I was coming here to take care of trying to make a payment plan.
Well, why would you make a payment plan? Listen to me. This is a courtroom right now, okay? It's a courtroom. Why in the world would you come in here and ask me to give you a payment plan if you weren't the one driving? Did you hear what I said?
Yeah. I don't want the warrant for my arrest.
Hang on. Were you driving or not driving?
I was not driving.
Why would you come in here and ask for a payment plan if you weren't driving?
That's what the officer said to do.
The officer said to come in and ask for a payment?
Take care of it.
Slow down. What officer?
I was pulled over yesterday in a car and they ran my name.
Did you tell him or her that you weren't driving on this date?
Yes, and they said to come to court, open court to take care of it, and that's what they did.
No, I thought you just said the officer told you to come in here and make a payment.
To take care of it. that's what I'm here to do.
Ma'am, I need you to post a bond. I'll be glad to entertain a motion to set aside default, but the rules are the rules. And you have to file a motion. And it doesn't have to be lengthy. They have them down there, and post a bond equivalent to the amount of the judgment, which right now is $237. Are you still maintaining you weren't the driver?
Yes,
You have a credit card you can put this on?
no, I brought $40 to make a payment. I don't have it.
Why would you, listen to me? We don't live in Russia. I know it's just a civil infraction, but you don't come in here and start paying tickets if you weren't the driver. Now, your friend's going to have a problem because she's going to get charged with false information to an officer. You understand what I'm saying? You post $237 within 7 days, and you fill out a motion to, I think it's seven. You post 230, go borrow some money. Come on back. File a motion to set aside the default judgment. Okay? You can go right down the hall. I'm not taking your $40 now. Save that for towards your 237. Okay? You shouldn't be coming in here. You don't want this up. No, it's not. Come on. I hope you guys people have more confidence in the judicial system than that, where they think if somebody uses their name and writes their friend a ticket, and the friend doesn't split, I hope you still friends with this girl?
Well,
Are you still friends with this girl?
was with me.
Well, how can you be friends with somebody that just got you in trouble by giving false information to a police officer? I'm just telling you, I'm not going to give you advice on who to choose and not to choose as friends, but somebody did that to me. Get out of my house and evict if you have to, and you're done with me. What kind of friend is that? Who needs enemies if you got friends like that? 237, post it within 7 days. Come in, file a motion. Okay, good luck to you. I wish you well. Listen, we're going to treat you fairly, but you have to write in the motion that this wasn't you, and you just found out on January 12th when the officer pulled you over, okay? Make sure you come back with that money. Good luck. The LBNV versus Thomas Hageman, 2503867.
Good morning, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
Good morning. Mr. Hageman, your name, sir?
Thomas Hageman.
All right.
Good morning.
We're going to conduct what, a pre-trial today? Is that what we're doing?
We don't need to, Your Honor. This case is resolved. I personally am in possession of Mr. Hageman's signed consent judgment, so we can file that on e-file today at some point.
Okay, is that true, Mr. Hageman?
Yes.
Okay, so you're going to file that today, Mr. Stratton?
Yes, Your Honor. Someone will file that today.
Okay, I guess I need you to state your name. I don't know if you did. Maybe you did and I missed it.
Mine, Your Honor?
Yeah, maybe you did and I missed it.
Yeah,
don't
I did.
know.
That's okay. Trevor Stratton, P65124.
All right, send it over. You guys are all set. I wish you well. Thank you. Jeffrey J. Twardzik versus
Thank you, Judge.
Priority Waste, 2503946R.
Good morning, Your Honor.
Good morning. Mr. Twardzik, your name?
Jeffrey Twardzik.
Where is somebody from Priority Waste? I don't see
Your
any.
Honor, they have not checked in this morning.
What
And I
is
know this
that?
was a review, so I wasn't sure if,
Review for what? Did we not get a judgment when we were supposed to get a judgment?
no, I believe there was an arrangement or an agreement that was made. We were waiting on
Did we get
parties
the
to
paperwork?
exchange.
Did you sign the paperwork yet, Mr. Twardzik?
Your Honor, I did not because I have not received payment yet, and I advised that to the attorney, Mr. Dillon.
Call Priority Waste. I want him online, please, Jennifer. Zeal
Okay, I'll call
Credit
Mr.
Union
Dillon.
versus Carrie Moore, 2504152. Did you get a hold of Ms. Ford, Jennifer, or Lisa?
She's here.
Yes, he just.
Okay, good. Do I have somebody here from Zeal? Yeah.
Yes,
Ms.
good morning, Your
Solomon,
Honor.
Good morning.
Yep.
Your name?
Alexis Solomon, P87454, appearing on behalf of plaintiff.
Ms. Uwe?
Good morning, Your Honor. Jocelyn Uwe, P64890 on behalf of the defendant.
Good morning to you. Today is the date scheduled for pretrial. Do you guys just want dates or did you resolve it?
We would just like dates, Your Honor. We are resolving. We're in settlement discussions right now.
Can I have a pretrial order, please? Or do I have them up here? Oh, here. Okay. All right. So let me see here. Is there a defense to this, Ms. Uwe?
Your Honor, it's the intent of the defendant to make the repayment plan. We're just trying to iron out the final details.
Can I just set this for trial or do you guys want discovery?
Discovery. Yeah, discovery if possible.
All right. Discovery cutoff will be on March the 1st of 26. No ADR, no motions dated trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. No jury. We're going to give you a trial date in latter part of March. I'll put down estimated time for trial 1/2 hour, and you do have to file your witness list by February the 6th. So February 6th, the 26th witness list due. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial. And I also have, let's see here. Deal, let's see. What's the trial date going to be? End of March, I'm thinking.
Judge, April 7th at 10:30.
April 7th at 10:30. Okay. So I'll
Thank
send
you, Your
this
Honor.
out to you guys. And you need this part.
No.
Okay. So we'll send this out. Anything else, Ms. Solomon?
No, that's it. Thank you very much, Your Honor.
How about you, Ms. Uwe?
No, nothing else, Your
Sorry.
Honor. Thank you.
Stady, here you go.
Good morning once again, everybody. Welcome to TCF Live on a Tuesday. Chaos Gremlin Ellie is now sleeping, so hopefully this show doesn't get disconnected like the pre-show, although she is sleeping on my network cables, so fingers crossed. Courts are just now starting to come online. We'll continue for now with Judge McNally.
By Monday.
Why are you guys waiting so long? When were you here last? Mr. Twardzik, I need your name.
Jeffrey Twardzik.
Just because of bookkeeping and the holidays and being behind, and it's not, I'm just waiting.
I'll adjourn it 2 weeks. This is a review hearing date again.
Okay.
So
Mr. Twardzik, we're sending you the entire amount to you. You pay who you like, okay?
What do you have for me, Jen?
The 27th at 9:30.
Remember, that's the day I have court to school, right?
Yep.
Okay, 27th at 9:30. Thank
Okay.
you both. Have a good day. Thanks.
Appreciate it. Thank you.
First National versus John Kovacs. First National, are you ready on yours? What are we doing on that? Okay.
Ready, Your Honor.
Let me take this one first. First National versus John A. Kovacs, 240424. Mr. Kovacs, you have to start your video, please.
Yes, sir. I was just trying. Sorry.
That's fine. Your name?
John Kovacs.
And Your Honor.
What
for
did
the
I
record,
do last time, counsel? I reinstated the case.
I don't think we did actually, Judge. I think we were waiting to see if the defendant would file bankruptcy. He had, again, Albert Kim, P70301, appearing on behalf of plaintiff. We appeared last, I believe in earlier mid-year sometime. I can't remember the exact date, but defendant had a bankruptcy order where he was not permitted to file bankruptcy until November. He didn't do so, so we refiled our motion. He has since filed bankruptcy as of January 9th, so our matter is resolved.
So you're going to present an order staying the case, right?
Staying the case. I believe it's already stayed, Judge. I think this motion was to reinstate. I don't think we ever reinstated or no.
Well, you filed a motion, I think.
And I think we decided to hold off on it just based on the fact that he expressed intent to refile. So I didn't want to come back here again. And of course, just took a little bit longer.
Wait a minute. I thought we were up for a motion to reinstate.
We were, Judge. And again,
so now he's filed bankruptcy, right?
Yes.
So you still need to file a motion, bankruptcy stay order, right?
I'll get one to the court then. Absolutely, Judge.
That's what we'll do. File your bankruptcy stay order, please. Thank you very much.
You have a great day and Happy New Year, Judge.
You too. Same to you guys. People against Peter Flash IV, 25F2726113. All right. Good morning, Ms. Ford. How are you? Okay. Sure, your name?
Peter Lockerford.
All right, go ahead. I'm sorry.
Gave us this opportunity to return because I tried to get a deviation report to Gary Breshman. I had the wrong email. Eventually I did, thank you, as a result of the adjournment, get it to him. And he responded that he could get in a drug treatment court if we could get him in, and has to plead to the third. My client does not want to do it. He wants to waive the exam, and we'll file. Just to let you know, my client had to take a blood test because he said he was diabetic. So I think that we have some technical defenses that will probably be better off in the evidentiary. And it's been 20 years since he had his.
So they wouldn't give you the.
Because he has an automatic rule if you have more.
He has what?
Well, I guess it's his policy if you have 4.
Oh, he had 4?
It's 4.
But they were a long time ago, weren't they?
No, you remember well. The last one was 20 years ago.
Yeah. Well, I mean, the idea is to get people some help. I'm sorry that he wouldn't do that. I'd have loved to have had him. I'll go ahead and take the waiver. Call in the
You just said whatever I think is best.
call in the prosecutor, will you, John?
I was going by my client, what he wanted.
Yeah. So that's what you want to do, Mr. Lash?
Was it program under you?
Not if there's a waiver.
No, if he entered the treatment court.
If he was doing it here, but they're not offering him that, right?
Yes, they did. In my opinion, they did.
I thought you said they didn't.
No, they offered him if he pled though.
Well, you said plead to OWI 3. I can't take a plea to OWI 3.
I'm pretty sure that's true. And then I could get him in the treatment.
In Detroit.
Yeah.
Yeah. So I'm just disappointed that they're not gonna do it here, but that's neither here nor there.
Well, up to remain.
So, all right, let me just get the prosecutor in
You did the
here.
state prosecutor, right?
Yeah,
She got him.
Ms. Osmaro, right?
Right.
Just give me 1 second. All right, so sir, in the meantime, your lawyer is telling me that you wish to waive your right to an exam. Is that true? If you waive your right to an exam, you're waiving the requirement that they prove that the crime was committed and that you were the one who probably committed the crime of OWI 3, and you'll automatically be bound over for further proceedings to the circuit court. Do you understand that? Mrs. Morrow, your name?
Good morning, Your Honor. Natania Asmer on behalf of the people, BAA Cornbury.
Good morning. Listen, you did a no objection to waiver form last time. I'm going to need you to do one today. You don't have any objection to the waiver, correct? Can you write that up and send it in, please, real quick? So, sir, you understand everything that's going on here. You understand you're charged with a felony. If you waive your right to an exam, I'm sending you to Detroit for further proceedings. Anybody force you to give up your right to a preliminary exam? All right. Counsel, can you write that up for me, please?
You would plead to a third year
He can't plead to a third.
It downtown. Then if I found the.
Your Honor, we did this in Westland about 2 weeks ago. When I spoke to Gary Bresnahan, he's the APA who deals with all of our OWI clerks.
Right.
I did mention last time, he has a kind of a list of things that he looks for when giving offers for OWI clerks. One of them being it has to be a true third, because this was before he did automatically deny it. But he also did mention, and again, we did this on a case in Westland, he pleads to an OWI third in the district court, but he gets sentenced in circuit court, and then that's if the court allows him to come back and do some.
Just let him plead in circuit. Why would you not have him plead in circuit? I mean, it makes no sense to me. If he's gonna,
Come back for Supreme Court, but that's.
well, they can take it back. If they want to reduce it there, you can tell the judge, whoever it is, will be happy to entertain it, as long as I approve of the terms and conditions.
Thank you.
Okay, I'll be happy to take it. But I'm going to approve of the terms and conditions if there's a plea. So I don't want a circuit judge saying I got to give 120 days or, because I've gone over this on and on ad nauseum with the prosecutor's office. They want to say if they're, and I'm thinking that they're coming around. But I'm not going to take a plea if it says judge has to give a year if they're convicted of a crime, which would include expired license, improper plate, and silly things like fishing without a license. I'm not doing that. So if they want to conditionally send it back for my approval, I don't have a problem with that. Okay?
I understand, Your Honor, and the only reason we have that done as an OWI third in a different district court, Westland, was so that offer could stick with APA Gary Bresnahan, opposed to going down to our general trials where another prosecutor will be the one to make that decision. So
Well, if they pleaded to OWI 3 down there or here, I don't have any jurisdiction anymore. Right? How can I handle felony down there? I'm not a regional treatment court. No, I don't. I'm serious. There's regional treatment court in Taylor. I can't do that here. If it's pleading to an OWI 3, that's beyond our jurisdiction. If he's pleading to an OWI 2, that's within the framework of our jurisdiction.
I understand, Your Honor.
So, but I'm saying if they decide to plead to impaired 2 or OWI 2, and they want to remand, and I approve of the terms and conditions of the sentence agreement, I don't have a problem taking it back. But I'm not taking it back if I don't approve of the terms and conditions. So they can figure out how they want to do it down there. Do you understand everything that's going on? You have a charge of operating while intoxicated third, which is a 5-year felony. Our jurisdiction only goes up to OWI 2. I could take the plea, have you go downtown, get sentenced there, but it makes no sense to me here. None. Zero. Zip. Go down, let your lawyer work it out with the prosecutor. They've got a treatment court down there. This just took too long, you guys, really. I mean, so if you guys want to, but I want to be clear, I'm not taking back a case on remand unless I agree to the terms and conditions of probation, however they want to do that. Okay? All right. So you understand that you're going to be bound over for further proceedings to the circuit court.
Yeah.
And you understand that's a 5-year felony. And you understand you're waiving the requirement that they show that the crime was committed and that you were the one who probably committed the crime. Anybody forced you to give up your right to a preliminary exam? All right, I'll accept the waiver. PR bond is continued. AOI date will be January 27th. I still need you to put a form in here saying no. You don't have any objection to waiver, right?
No,
Pardon?
no, Your Honor.
Okay, good enough. That's fine.
Would you like me to go right?
Nah, don't worry about it. As long as you state it on the record. Thank you.
Thank you for your patience.
No problem.
Let's go to Florida. Wade Mercer, first appearance.
Good morning, Mr. White. Your girlfriend and her parents are both in, all three of them are in the courtroom. You're here because you've been accused of a new charge of uttering a forced instrument. Mr. White, there is probable cause in the complaint. This allegedly occurred on December 5th, which was after you were on probation for a different uttering a forced instrument. So, Mr. White, I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, and then we're going to listen to the state. Mr. McDaniel, anything on behalf of Mr. White?
No, Your Honor.
Mr. Mitchell?
We just request that a 7-day hold be put on him to decide whether or not probation is going to violate him.
Okay. Thank you. So, Mr. White, I'm going to set you a bond in a new case. I set a higher bond for people who are on probation. That bond's going to be $10,000 cash or surety. You have a condition of no contact with the alleged victim, but don't try to post the bond. The reason I'm telling you don't try to post the bond is you've got no bond for 7 days. Mr. McDaniel, you want to say something?
He's already been violated on his probation, so maybe if the court wants to go ahead and serve him or let him go and give him a court date on it, I'm not sure.
Because of there's a warrant out, or what do you mean he's already been violated?
There's a warrant out.
There's an active warrant. They just didn't bring it.
He turned himself in. So I know, but it's all right.
Okay, so there's no warrant in my packet. So, Sarge, y'all don't have a warrant.
Yeah.
Right. They didn't bring
right?
it. I just seen it this morning on CCIS when I was in here.
Okay. So in the system, when you haven't been served with it yet, there is a violation of probation warrant. So, Sergeant Applewhite, I'm going to ask you to contact the sheriff's department and tell them that when they arrested him yesterday, they served one warrant and didn't serve one. So he's at the jail, and we need to get this VOP warrant served on him. So there is already a violation of probation warrant, and I'm looking at it now, and it's based solely on the new charge. And the judge in that case, which is Judge Garcia, has issued no bond in the VOP. So I'm going to go ahead and first appear you on that also. You're accused of violating your probation, and I'm going to go ahead and get you arraigned on that. And the reason we're doing that is I want to get you an attorney appointed and get that case moving. So even though it hasn't been served on you, that hopefully that's going to happen today. We're going to go ahead and first appear you for that. Would you like to have an attorney appointed to represent you in the VOP?
Yes, sir.
All right. I'm going to appoint an attorney to represent you in the violation of probation. So I'm going to ask that you listen to Mr. McDaniel, and then we'll see if you have any questions in just a moment.
We're going to have to not guilty. He has to set this on the next docket, which would be February 5th, or it may be February 2nd, because his other case would be on February 2nd. I've advised him that one of the public defenders will come out and visit him. It'll probably be someone assigned to his new case that'll talk to him about the violation of state probation, but they'll talk to him about it before that court hearing, or it may be at that court hearing on February 2nd.
So February the 3rd. February 3rd will be your court date, and that's on the arraignment docket.
Yes.
February 3rd at 8:30. So it gets a little confusing. Mr. Guy Green is the assistant public defender that does violation of probations, but he does not do them usually if there's a new felony. Whichever attorney gets the new felony usually has a new felony and the VOP. So I don't know if it'll be Mr. Green, but more than likely it'll be a different assistant public defender. Whoever has him on the new charge will probably handle the VOP also. So your court date's going to be February 3rd. You've got no bond, at least for the time being, and the public defender's office has been appointed to represent you. Mr. White, do you have any questions?
Not at this time.
Does the family or friends have any questions?
There's another charge?
There's two charges. One is the new charge. One is a violation of probation based on the new charge. It's just one new charge, but there's a VOP. So he's got a bond in one, but there's no point in posting it because he's got no bond in the violation of probation. That no bond is set by the judge in that case. And actually, both cases will go before the same judge. Judge Garcia will have both cases. Any other questions?
What was that bond?
I set up a bond of 10 on the new charge, but he's got no bond on the VOP. Wish you the best, Mr. White.
I got this.
Thank y'all for coming. That's it for friends or family, so we can go back to the top of the list. The first case on the docket is Timothy Collette. Mr. Collette, come on up. Mr. Collette, you're here in case number 25-578MM. You're accused of violating the terms of your probation by leaving an inpatient drug treatment center. Mr. Collette, I'm going to appoint the public defender's office to represent you. And I do have a text, Mr. Mitchell, and I'm not sure if y'all are included on this or not. Sergeant Gross sent me a text. Mr. Collette's positive for THC, and Mr. White was negative for anything illegal. Okay. So, Mr. Collette, listen to Mr. McDaniel. We'll see where we go this morning. Mr. McDaniel.
Your Honor, we're going to admit that we violated county probation. Yes, 21 days jail credit, and just ask the court to sentence him.
21 days. All right. So, Mr. Collette, I need to explain to you a couple of things. Mr. Collette, you're accused of violating the terms of your county probation on a first-degree misdemeanor. Mr. Collette, you have the right to go to a hearing in this case. If you go to a hearing in this case, the state will try to prove that you violated your probation. Mr. McDaniel will be representing you to try to present any defenses you may have. That I would make a decision, or whatever judge hears the case, probably would be me, would make a decision of whether or not that's proven. On the other hand, you have the right to waive that right to a hearing and enter a plea and admit you violated your probation. If you waive the right to a hearing, you're also waiving your right to call and cross-examine witnesses at the hearing. There will not be a hearing if you waive it. I will listen to you. I'll listen to the state. I'll look at the file, and then I will impose a sentence I think is appropriate. Mr. Collette, knowing all of this, do you want to waive your right to a VOP hearing and admit you violated your probation?
Yeah. Yes, sir.
All right. I'm going to accept your admission. I'm going to find it no involuntarily entered with the advice of counsel. So, Mr. Collette, let me go over what the report says. And then I'm going to be glad to listen to you. So what you're accused of doing is, according to this file, last month, you were sentenced on December the 19th to 11 months and 29 days probation. The charge was first-degree misdemeanor criminal mischief. You were allowed to go to Chrome and serve your sentence at Chrome. Chrome Inpatient Drug Treatment Center, and as long as you completed that probation, that sentence there, that would satisfy your jail sentence. So if you completed Chrome, you were not to do any jail time, that sentence would be it. I'm not sure what day you went to Chrome. Mr. Goodson may know. But according to Chrome, you left on July 11th. January 11th, I'm sorry. Can you, I don't know if he can hear you, Mr. Goodson. Can you get in front of the microphone so he can hear you, please?
He got put on probation he was instructed on December 19th. Correct me if I'm wrong, John. I think he went that afternoon. Did he not?
I'm assuming he went out that afternoon. Yeah, he went that same day. That's my calculations were on that day.
Yes, sir. So he got put on probation on December 19th. My understanding is he went to Chrome on December 19th that afternoon. We received an email from Julie Jenkins yesterday alleging that on Sunday morning, Mr. Collette just walked out of the facility without any explanation. He called me yesterday morning. I told him there'd be a warrant issued for his arrest because he failed to remain on incomplete treatment. His mother called yesterday afternoon and said she was going to bring him to our office. I told her just take him to the sheriff's department and turn himself in.
Okay. So he stayed about 3 weeks, if my math is correct. So, Mr. Collette, that's what you're accused of. If anything you want to tell me or anything you think I need to know, I'm glad to listen. Or Mr. McDaniel, whoever.
I was just going to ask for one more chance at Chrome.
Yeah, that's not going to happen. Any other request? I'm not going to let you go back to Chrome. I let you go. You stayed 3 weeks and you left. I don't know that I've ever let someone go back. And I'm not going to let you go back there. I think there's a limited number of beds. We need those for people that want to be there. And
all right.
You had your shot. So I do appreciate you turning yourself in the same day or the next day after you left. I'm not sure which.
So I received a letter from Chrome.
He turned himself in Monday. Okay. Yeah. So it was the next day. And I appreciate that. It's not like you were gone. I had one yesterday. That gentleman was gone 7 months. So I am going to take that into account, and I'm going to take that's going to show in your sentencing. The other thing I appreciate is you only had THC in your system. Had you had methamphetamine in your system, that would be something I would want to know. But so I'm aware of that. But the chance of me letting you go back there after this is it's just not going to happen. But if there's something else you want to tell me or ask, I'm glad to listen, Mr. Collette.
No, sir.
Mr. McDaniel, anything on behalf of Mr. Collette?
No.
Anything else? Mr. Mitchell?
I think you said pretty much everything, Your Honor.
Mr. Collette, your original offer was 6 months in jail, but I'm not going to sentence you to something that would let you do less time than you would have done in Chrome. Chrome would have been 6 months inpatient, I believe, perhaps 9 months. I'm not sure. Yeah. Okay. So what I'm going to do, Mr. Collette, is I'm going to sentence you to 9 months in jail. I'm not going to sentence you to the full 11 months, 29 days that you were offered this morning because I think you should be rewarded for turning yourself in. And I'm also appreciate the fact that you did not have methamphetamine or something like that in your system this morning when the jail tested you. So I'm going to sentence you to 9 months in jail. You do have credit for the time that you served. And Mr. McDaniel, that was 20, how many days?
21 days.
21 days. Any court costs and fines that remain unpaid, which are probably all of them,
$370.
370 court costs and fines. You'll get a chance to work off those. And Mr. Collette, because we started doing these on probation now, you are better off than under the old system. Under the old system, you were sentenced to jail and leaving would have been breaking a jail rule. Under the new system, this is a probation violation. So you haven't broken a jail rule. So as far as I know, you still may be eligible for both state and county gain time, which could be up to 10 days a month off of your sentence for good behavior. So talk to the jail about the trustee program. But there's no probation involved in the sentence. And this is the first court date you've had that your mother hasn't been here. I don't know if she wasn't aware you were coming up or if she's just unavailable this morning. But if she calls our office, we'll let her know what the sentence was. Mr. Collette, I do wish you the best. Do you have any questions, sir?
No, sir.
Wish you the best, sir.
Yes, sir.
Next case is Carrie Walk. Ms. Walk, good morning. Ms. Walk, you're here for first appearance, ma'am, accused of one count of possession of methamphetamine and one count of possession of drug paraphernalia. Ms. Walk, there is probable cause for both these charges. I've looked at your criminal history, ma'am. It appears to me that I'm aware that according to the Department of Corrections website, you've been to prison 3 times. So I'm aware of that. But I think you're entitled to a bond as far as I can tell. So I'm going to see if the attorneys have any additional information, and then we're going to address that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell.
We just request you be subject to random UAs.
Ms. Walk, I'm going to set you a bond of $7,500 on the felony, $3,500 on the misdemeanor. Your total bond is $11,000. It's cash or surety. That's important, ma'am, because surety means you can go through a bondsman. You do not have to come up with all that money. And ma'am, you do have a condition of random analysis. So if myself or Judge Garcia or any judge in your case drug test you and or ask that you be drug tested, then a positive result without a prescription could result in a violation of revocation of that bond. Ms. Walk, you will get to use the phone in just a few minutes, ma'am, to try to post the bond. The jail is also going to give you a notice for your court date. Your court date will be February the 3rd at 8:30 a.m. and they'll give you that notice. Ms. Walk, do you have any questions?
No, sir.
Have a good day, ma'am. Deontay Bellamy is next. Mr. Bellamy, good morning. Mr. Bellamy, you're here for first appearance accused of one count of trespassing. Mr. Bellamy, there is probable cause in the complaint in your case. And I looked at your criminal history in, I think, 3 different states. So I'm familiar with that somewhat. Mr. Bellamy, I'm appointing the public defender's office to represent you. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Yeah, we just asked for a reasonable bond.
Mr. Mitchell, anything?
No, Your Honor.
Mr. Bellamy, given your criminal history, I'm going to set your bond at $5,000 cash or surety. You have a condition, have no contact with that property at all. You cannot go back to that property for any reason that you're accused of trespassing at. We're also going to give you a notice for your court date. Would that be the 2nd? February 2nd at 9 a.m. will be your court date, Mr. Bellamy, and they'll give you that notice in just a moment. Mr. Bellamy, you'll get to use the phone shortly to try to post the bond. Just don't go back over there where they're accusing you of going. Mr. Bellamy, do you have any questions?
No, sir. Not right now.
All right. Wish you the best, sir. After Mr. Bellamy, the last case for the morning, I think, is Blake Larkham. Mr. Larkham, good morning. You're here because you've been accused of one count of petty theft. Mr. Larkham, there is probable cause for the charge. I'm going to appoint the public defender's office to represent you, Mr. Larkham. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Larkham. He's going to accept the PTI for 6 months. Restitution not to exceed $16.75. And there'll be a $370 fine. And he can only terminate after 3 months. If he gets everything completed, takes a retail theft class, and does everything he's supposed to do.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. Was that an added condition of the retail theft count?
He did. He did put that in there. Mr. Larkham, is the address on Penn Avenue, is that your correct address?
It's one of my addresses, sir.
Okay, you have to give one address to the probation office. Is that where you're normally at? Is that where you get mail at?
Yes, sir.
It's just unusual to see a Penn Avenue address and a I think it's a Dollar General in Sneeds is the alleged,
Where you want your mail to go?
Sneeze.
well, it just says,
I would like my mail to go to, the Penn Avenue address.
okay, all right, the Family Dollar in Sneeds. It's just unusual, so I didn't know if that was a typo. Yeah, there's going to be no contact with Family Dollar. So, Mr. Barkham, you need to understand if you enter this PTI agreement, part of that PTI is a no contact with any Family Dollar while this case is pending, and it's technically pending while you're under the supervision. The other thing you got to understand is part of this PTI is a conditional release. So that means it kind of gives some teeth to that program. If you don't report in like you're supposed to, if you commit a new crime or charged with a new crime, if you have contact with Family Dollar, then you could go to jail without a bond. So you have to take it seriously. Mr. Larkham, the good news is if you do what you're supposed to do and stay out of trouble, then this case against you is going to be dismissed. You follow all the rules of the PTI, it'll be dismissed. Mr. Larkham, do you have any questions about the PTI agreement?
No, sir.
And you do want to participate in the PTI, right?
Yes, sir.
I'm going to show you a case referred to the PTI program for the terms and conditions Mr. Mitchell and Mr. McDaniel and myself placed on the record. Mr. Larkham, that's 6 months, possible dismissal after 3 months if you get everything done. If you need the full 6 months, that's okay too. Mr. Larkham, what's going to happen next is the jail's going to let you use the phone for transportation purposes if you want to. Then they're going to let you get dressed in your regular clothes, Mr. Larkham, and then they're going to bring you to the courthouse because that's where the PTI office is at. It's the same as the probation office. When you get here, Mr. Goodson or Mr. Ham, one of the PTI officers, will go over the PTI with you. They'll answer any questions you have about the PTI. They'll give you a copy of all the rules in writing, and then you'll be free to leave. Mr. Larkham, do you have any questions you want to ask me about the disposition?
When will this happen? I go to the courthouse.
Probably about 30 or 45 minutes from now.
Okay, yes, sir.
All right, wish you the best.